Good evening and welcome to the Marian Minor Cook Athenaeum. My name is Hamsa Shrikant and I'm one of the 2 Ath Fellows this year. So the reason I love the Athenaeum, this venue right here, is because it has played a formative role in shaping my college experience. Like a lot of you here tonight, the Ath provides me with a space where I can wear a nice dress, meet interesting people, and have nuanced debates as I stuff my face with bread. The Athenaeum, in this way, underscores CMC's commitment to intellectual curiosity and freedom of speech. This commitment, however, was challenged in April 2017 when Heather McDonald's talk was shut down by protesters from across the Claremont colleges. The reaction to this event was polarizing and raised more questions than it answered. Where do we go from here? What are emerging issues likely to face campus administrators? How can campus safety be balanced with free speech? Our speaker tonight will discuss the principles that campuses should follow in regards to freedom of speech. Erwin Chemerinsky is Dean and Jesse H. Chopper Distinguished Professor of Law at UC Berkeley. Prior to assuming this position, he was the founding Dean, Distinguished Professor of Law, and Raymond Pike Professor of First Amendment Law at UC Irvine School of Law. He has also been a distinguished professor at Duke University and University of Southern California Law School, and has taught at DePaul College of Law and UCLA Law School. He teaches constitutional law, First Amendment law, federal courts, criminal procedure, and appellate litigation. He is the author of 10 books, including The Case Against the Supreme Court and The Closing of the Courthouse Doors. Dean Chemerinsky is also the author of more than 200 law review articles. He writes a weekly column for the Sacramento Bee, monthly columns for the ABA Journal and the Daily Journal, and frequent op-eds in newspapers across the country. He frequently argues appellate cases, including in the United States Supreme Court. In 2016, he was named a Fellow of the American Academy of Arts and Sciences. In January 2017, National Jurist magazine named Dean Chemerinsky as the most influential person in legal education in the United States. He received his Bachelor's of Science from Northwestern University in 1975 and his JD from Harvard Law School in 1978. Dean Chemerinsky will deliver the 2018 Salvatore Center's Lofgren Lecture on American Constitutionalism. As always, I must remind you that audiovisual recording is strictly prohibited. The Athenaeum is a community and gathering space, and the use of cell phone, be it for texting or for reading the news, greatly diminishes the social experience for others. Please use this opportunity to put away any of your devices and adjust your seat if you have not already done so. Notes and pencils are available on each table should you want to ask questions later on. And without further delay, please join me in welcoming Dean Chemerinsky.
All right. Good evening. It's truly an honor and a pleasure to be with you. It's very special for me to get to deliver the Lofgren Lecture. I've long been an admirer of Professor Lofgren's writings. In fact, if you look at my constitutional law casebook, there's a long excerpt from Professor Lofgren's article. So I know he's here tonight. Could I ask we all recognize Professor Lofgren? I also tell you this is very special to me for a personal reason. My wife's father, Winston Fisk, was a longtime professor of political science here at CMC. She grew up in Claremont, so getting to come and speak here tonight is really extraordinary. Free speech issues on campus are nothing new. They've probably been there as long as there's been colleges and universities. Yet I have the sense that things have changed in recent years. For me, perhaps for most people, the image of free speech on campus was so shaped by what occurred at Berkeley in the mid-1960s with the free speech movement. There it was students on campus demonstrating, claiming the right to speak on campus for things unrelated to school administration. For example, the college Republicans want to discuss the coming nomination of Barry Goldwater. It was the campus administration that tried to squelch the expression. Today, so often, it's about outside speakers coming onto campus to use it as a platform. It's about Richard Spencer, the white supremacist, going to Charlottesville, or Milo Yiannopoulos coming to Berkeley. Other things have changed as well. Student attitudes towards free speech have shifted. A study not long ago by the Pew Research Institute found that 42% of undergraduates surveyed believe that campuses should stop offensive or hateful speakers. Now, I'm not one who believes that this is just about so-called snowflakes. I think this is the first generation of college students to be educated from a young age that bullying is wrong. I find it laudable that they've internalized that message and they want to protect their classmates. Other things seem different now, too. Over the last couple of years, I've had the sense that in our society, a rock has been turned over, and people feel comfortable saying hateful things in public in a way unheard of before. I don't know if you read the signs that were held up at Charlottesville a year ago, August. One of the signs said, and I quote, "Kikes belong in the oven." I'm 65 years old. I don't remember ever seeing such a sign held up in public. Last October, Harvard law professor Alan Dershowitz came to speak at Berkeley Law School. It was tense. Dershowitz, as you may know, is a staunch supporter of President Trump and an ardent supporter of the policies of the current Israeli government. But it went off without incident. Students asked respectful, though challenging, questions. That afternoon, someone drew a swastika over Dershowitz's picture that's on a poster on a law school bulletin board. I've been a law professor for 39 years now. I've never been in a law building on a campus where someone drew a swastika on the bulletin board. So all of this is the context for talking tonight about issues of free speech on campus. I've increasingly become convinced that it's important to separate a discussion of what the law is from talking about what the law should be. I saw that very vividly on the Berkeley campus last fall. The group on campus called the Patriots and College Republicans invited a number of controversial speakers in what they said was going to be Free Speech Week. These were to include Ben Shapiro, Milo Yiannopoulos, Steve Bannon, Ann Coulter, Charles Murray. In anticipation of this, the Chancellor, Carol Christ, called a campus-wide forum with a faculty panel to speak on what I'm talking about tonight, free speech on campus. One of the first speakers was my colleague, John Powell. He said, "The largest problem in society is white supremacy, and the campus should exclude any hateful speakers." There was resounding applause from the audience. Then went on, after all the speakers had addressed the audience, to questions and answers. And a student stood up and spoke very eloquently and powerfully and said that she feels threatened when there's hateful speakers on campus. And she wants the chancellor to stand up for the students and to exclude any hateful speakers like Milo Yiannopoulos, no matter what the First Amendment requires or no matter what the court says. And there was resounding applause. Towards the end of the discussion, I spoke up as one of the faculty members on the panel. And I said, "Be clear. If Chancellor Christ were to exclude these speakers, she would get sued and she would lose. When Auburn University excluded the white supremacist Richard Spencer, Spencer and his supporters sued. They won. I said, the university will have to pay the excluded speaker's attorney's fees. I said, because the law is so clear here, the chancellor might even be personally liable for money damages. I said that the excluded speakers will make themselves out as martyrs and victims. I said, nothing's going to be gained. They'll get to speak anyway. No one applauded when I said that. And that it is a correct description of the law. So I thought what I would do this evening is identify 3 principles that summarize the current law, try to show you where the law is clear and show you where it's unclear, then apply those 3 principles to some of the cutting-edge issues with regard to free speech, and conclude with some of my thoughts about the obligations of colleges and universities to create both a safe learning environment for all students and protect freedom of expression. So the first principle that I identify is that all ideas and views can be expressed on a college campus. Period. Now, in discussing this, I'm focusing on public universities. As you may know, the Constitution and the First Amendment apply only to the government. Private institutions, like this college, don't have to comply with the Constitution. Now, the law is a bit more complicated than this. So, for example, there's a statute in California, the Leonard Law, that says that a private university, or for that matter, a private high school, cannot punish speech that a government institution cannot punish because of the First Amendment. So by statute, certain principles of free speech are applied to private institutions. Also, in every college, there's a faculty handbook, there's a student handbook. They usually contain statements about the importance of freedom of speech, academic freedom. Many courts have held that those faculty and student handbooks constitute a contract between the institution and faculty and students, respectively. But what I'm speaking of more than anything else applies to public universities. It is this basic principle that the Constitution applies to the government. It doesn't apply to private institutions. My favorite illustration of this comes from a true story of a conversation I had with my oldest two children when we were in the grocery store 26 years ago. They were 9 and 6 at the time. Diet Coke was giving away free baseball cards. 3 were pictured on the outside of the package. As we went up and down the aisles of the grocery store, my 2 sons were fighting, as they often did at that age, but who was going to get the extra baseball card? Finally, I said, "Be quiet. I don't want to hear anything about baseball cards to leave the grocery store." My then 9-year-old turned to me and said, "You can't tell me to be quiet. I've got freedom of speech." I was ready for him. I said, "Freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can." To which he, without missing a beat, turned to me and said, "Well, you're like the government to me, so you shouldn't be able to tell me to be quiet." It's when I first knew someday he was going to go to law school, and he's now a federal prosecutor in Los Angeles. But I think that private universities, because of their commitment to academic freedom, their commitment to open inquiry, should follow the same principles as public universities, even though the Constitution doesn't require it. And to me, that core principle is that all ideas and views can be expressed, no matter how offensive, even deeply offensive. And there's a Supreme Court case about this in the First Amendment from several years ago. It's a case called Snyder versus Phelps. It involves a small church out of Topeka, Kansas, the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and use them as the occasion for expressing a vile anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church traveled to Maryland, where his funeral was going to occur. Before the funeral service, the members of the church asked police officers where they could lawfully stand. The officers pointed an area about 1,000 feet away from the funeral would be conducted. Before the service, the members of the church chanted and sang. During the service, they were silent, but they held up signs. That night, Matthew's father, Albert Snyder, was watching the news. He was able to read the signs. He was deeply offended. He sued for invasion of privacy and for intentional infliction of emotional distress. A jury awarded him $10 million in damages. But the United States Supreme Court ruled 8-1 that the members of the Westboro Baptist Church could not be held liable. Chief Justice Roberts wrote the opinion for the court. The court made clear the government cannot prohibit speech, punish speech, create liability for speech on the grounds that it's offensive, even, as I said, deeply offensive. Second principle that I would identify is that free speech is not absolute. There are categories of unprotected speech. I'm sure you're all familiar with the famous words of the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. at least since 1942, in Chaplinsky versus New Hampshire, the Supreme Court has said there are categories of speech that are unprotected by the First Amendment, where the government can prohibit and punish the expression. Child pornography is unprotected speech. False and deceptive advertising is unprotected speech. For our purposes, in talking about free speech on campus, there are three categories of unprotected speech that are relevant. One is incitement of illegal activity. For this, like all of the categories, it's important to separate the colloquial use of the word from the legal test. The legal test for incitement comes from a Supreme Court case in 1969, Brandenburg versus Ohio. There, the Supreme Court said the government can punish advocacy if there's a substantial likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. Let me make this less abstract. Imagine a person comes to this campus and the person exhorts an angry crowd to commit acts of vandalism, to commit arson of buildings. I think under those circumstances, that speaker constitutionally can be punished. If there's a substantial likelihood of imminent illegality and the speech is directed at causing it, it's not protected by the First Amendment. But compare that to another instance. Imagine there's a very controversial speaker who comes onto campus. Make it Milo Yiannopoulos. And imagine that the audience commits acts of vandalism, is trying to prevent that person from speaking. The speaker can't be punished because of the reactions of the audience. The reactions of the audience can't be a basis for suppressing the speaker. Otherwise, any audience could silence the speaker just by threatening violence. A second category of unprotected speech is true threats. The phrase true threats actually comes from a Supreme Court case in the mid-1960s, United States versus Watts. It involves a federal law that's still on the books that makes it a federal crime to threaten the President of the United States. The Supreme Court upheld the constitutionality of that statute, but the Supreme Court said it's important to draw a distinction between, quote, hyperbole and a true threat. The court said true threats are what's unprotected by the First Amendment. There's actually a split among the lower courts in terms of how to determine what's a true threat. I think the better approach is to say there's no First Amendment right to cause a reasonable person to fear for imminent harm to his or her physical safety. Let me again give you a couple of examples. Imagine that a student is walking across this campus. Imagine an angry group surrounds that student. The angry group yells things at the students that cause the student believe that he or she is about to be beaten. Even if no blows are struck, that's not speech protected by the First Amendment. There's no First Amendment right to cause somebody to fear imminent danger to his or her physical safety. On the other hand, at Berkeley last fall, I heard several students say that they feel threatened by the mere presence on campus of hateful speakers. That's not enough under any definition a court would accept of what constitutes a true threat. A third category of unprotected speech is harassment. There's not many cases yet that have come up in the context of education as to when speech constitutes harassment that's not protected by the First Amendment. But there's a lot of cases in the workplace context. Their courts have said that speech that constitutes harassment isn't protected by the First Amendment. It can be a basis for liability. Start with the easiest example. An employer says to an employee, "Sleep with me or you're fired." The employer is sued for sexual harassment. It is no defense for the employer to say, "But it was just speech, just words." The courts have gone further and said that speech can be a basis for liability if it's directed at somebody or it's so pervasive as to materially interfere with employment opportunities based on race, sex, religion, sexual orientation. I think the same standard can be applied to college universities. If speech is directed at somebody on account of a characteristic like this, or if it's so pervasive as to materially interfere with educational opportunities based on race, sex, religion, sexual orientation, then it's not protected by the First Amendment. Again, let me give a couple of examples. There was an incident at Duke University, where I was professor for a time, where someone draped a noose over a tree, or it was a rope that appeared to be a noose. That wasn't speech, I think, that if the First Amendment applied, could be punished. In fact, there was a similar incident at the University of California, San Diego, where the First Amendment doesn't apply, where what appeared to be a noose was left in the library. The single incident, not directed at anybody, couldn't be regarded to meet the standard of harassment. But imagine that somebody tacked what appeared to be a noose on a door in a dormitory of a room occupied by an African-American student. I think that could be regarded as harassment, and whoever did that could be punished. Of course, there's difficult line drawing as to when does speech rise to the level of harassment, but there's line drawing with regard to all of these categories. Now, you'll notice as I went through these categories, incitement, true threats, harassment, what I didn't mention is a category of unprotected speech, and that's hate speech. That's because hate speech is generally protected under the First Amendment. I have so often been asked by reporters, by people in audiences, of where is the line between free speech and hate speech? That's a false distinction, because the Supreme Court has said that generally hateful speech is protected as free speech. Now, as I talk about hate speech, I do not in any way minimize the harms of hate speech. If free speech had no effects, it wouldn't be protected as a fundamental right. The impact of free speech can be very positive. It can enlighten and uplift us, or it can be tremendously hurtful. And hate speech is very hurtful. And I'm moved by scholars like Charles Lawrence and Richard Delgado and Mari Matsuda, who've talked about the tremendous harms that hate speech inflicts on campus. And yet the United States Supreme Court has been clear that hate speech is protected by the First Amendment. There's a famous incident in Skokie, Illinois, in the late 1970s and early 1980s. Skokie is a suburb just north of Chicago. At the time, it had a large Jewish population. At the time, it had a large population of Holocaust survivors. The Nazi Party deliberately chose Skokie as the place for its demonstration. The village of Skokie did everything it could to try to exclude the Nazis. Every court, though, including the United States Supreme Court, ruled that the Nazis had the right to march through Skokie, despite how upsetting, despite how offensive the speech would be to the residents. There's a Supreme Court case in 1992, RAV versus City of St. Paul. St. Paul, Minnesota adopted an ordinance prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. These are vile symbols of hate. But the United States Supreme Court unanimously declared that ordinance unconstitutional, saying that even hate speech is protected under the First Amendment. Why? Every European country has a law that outlaws hate speech. Why not the United States? I think there's several reasons. One is the inability to define what's hate speech in a manner that's not unduly vague or overbroad. Any law, including any regulation of speech in a public college, has to be specific about what's prohibited and what's allowed. It can't regulate more speech than the First Amendment would allow to be controlled. And yet no one's ever found a way of defining hate speech that's not impermissibly vague and overbroad. In the early 1990s, over 360 colleges and universities adopted so-called hate speech codes. Everyone to come to court, without exception, was declared unconstitutional. Take as an illustration the University of Michigan. After a series of ugly racist incidents, the University of Michigan adopted a hate speech code. It prohibited speech that stigmatized or demeaned on the basis of race, sex, religion, sexual orientation. But what does it mean to stigmatize or demean? Michigan actually modeled that language of many European laws prohibiting hate speech. A sociobiology graduate student was one of the plaintiffs who challenged it. He said his research was about whether there are inherent behavioral differences between men and women. He said he worried that he might be found to be stigmatizing or demeaning on the basis of sex. When you look at the European hate speech laws, you see the exact same kind of language. A couple of years ago, when I was still at UC Irvine, I co-taught a seminar on free speech on campus. I did this with the chancellor there, Howard Gilman. And one of the things we asked our students to do was to try to draft a hate speech code. And I think what our students found, what campus found around the country, is the inability to define it in a manner that's not impermissibly vague and overbroad. Also, the experience under these hate speech codes and our hate speech laws should cause us pause before embracing them. The experience has been that much more often than not, they're used against the very groups that we seek to protect. From the time the University of Michigan adopted its hate speech law until the federal district court declared it unconstitutional, every enforcement action under it, without exception, was brought against African American and Latino students. When England adopted its first hate speech law, the initial prosecution under it was brought against a Zionist group. The prosecutor said he believed that Zionism should be regarded as a form of racism. France has long had a hate speech law. The most frequently prosecuted person under it is the actress Brigitte Bardot. She's an animal rights activist, and she's very much against the use of animals in religious ritual observances. When she's spoken out about that, she's several times been arrested. But maybe most of all, the reason why hate speech is protected in the United States is it expresses an idea. It's a vile idea, but it's a view nonetheless. The late Justice John Marshall Harlan in Cohn versus California said, "To censor words is to censor ideas. We can't cleanse the English language to please the most squeamish among us." Well, this then brings me to my third point, and that's that colleges and universities can have time, place, and manner restrictions with regard to speech, so long as they leave open adequate alternative places for communication. Even when there's a right to use government property for speech, it doesn't mean that that property has to be available at all times for all manner of expression. The Supreme Court has said there's a right to use public streets and sidewalks for speech, but it doesn't mean there's a right to have a demonstration down in the middle of the freeway at rush hour. And so the law has long said that the government, and the same would be true of private institutions that want to protect speech, can have time, place, and manner restrictions. I think for college and universities, they're especially important to prevent disruption of campus activities and also to protect safety. With regard to preventing disruption of campus activities, there's no doubt that a college or university can say there can't be demonstrations in or near classroom buildings when classes are in session. Colleges and universities can have free speech zones, so long as they truly allow adequate opportunities for communication. Time, place, manner restrictions also can be used to protect safety. Colleges and universities have a legal as well as a moral duty to protect the safety of students, staff, and faculty. When I arrived at UC Berkeley a year ago summer, Chancellor Carol Christ very kindly asked for my advice with regard to dealing with the coming Free Speech Week. And I said, my suggestion would be have the most controversial speakers be in an auditorium rather than the open area of the campus. I said if they're in an auditorium, that you can then require identification or student badges in order to be able to get in. I said if it's in an auditorium, it's easy for police to control the perimeter. If necessary, you can have metal detectors before people walk through the door. I said once it's an open area of the campus, Sproul Plaza in the middle of Berkeley, you can't do any of those things. And so when the conservative commentator Ben Shapiro came, he was allowed to speak in the largest auditorium on campus, Zellerbach Hall. And I think this was one way of ensuring safety, and it went off without incident. Now, I think one of the hardest questions for colleges and universities, and where there's no clear legal answer, is how much money do they have to spend so as to ensure safety? Where is the point at which a college or university could say, we can't afford the costs of safety here, so we're not going to allow the speaker? Berkeley last fall spent $3.9 million on safety when it came to having just a few controversial speakers come onto campus. Chancellor Christ was kind enough to ask me this question as well, and I responded by saying, I wasn't her lawyer, she has campus counsel. If I were a lawyer, I would tell her there's no clear answer to that. No court has yet addressed it. The most any lawyer could say is you have to spend a reasonable amount. Now, she's much too polite to roll her eyes at me, but saying to a campus administrator you have to spend a reasonable amount doesn't give much guidance. And I said, if I were your lawyer, I would tell you there's two things you need to think about. One is, what's your stomach for litigation? If you exclude a speaker because you don't want to pay the costs of security, you're going to get sued. It's impossible to predict the outcome of that suit because the law hasn't developed. If you lose, you have to pay the other side's attorney's fees. And the second is, what do you want your message to be at this moment in time? She decided she wanted the message to be that Berkeley is a free speech campus, and she allowed the speakers paid the cost of safety. But what if it wasn't Free Speech Week? What if the same group said this is free speech semester? And what if the cost was not $3.9 million, but $40 million? Every dollar spent is coming away from the educational mission of the school. Where is the point at which the university can say, we just can't afford the costs? Some campuses, like UCLA, are taking a new approach this year. UCLA is saying, we're going to allocate this much money, I think it's $100,000, to security for controversial speakers, and after we exhaust that fund, then we're just not going to allow controversial speakers onto the campus if there'd be safety concerns. My own sense is that's likely unconstitutional. I'm not even sure how a court would approach a number like that. Is it relative to the UCLA campus budget? Relative to the whole UC budget? Relative to the state of California budget? But you can see that campuses are struggling with this, and courts are going to have to deal with it in the years to come. So those are the three basic principles in describing the law. Let me try to apply them to some of the issues that are arising now. One issue that comes up is so-called no platforming. This is where students try to keep a controversial speaker from being able to appear, saying we don't want the campus to give a platform for this speaker. It occurred a number of years ago at UC Irvine, when I was there. The Israeli ambassador, Michael Oren, was coming to speak. As soon as he started his remarks, the student stood up and yelled so Ambassador Oren couldn't be heard. That student was escorted out. As soon as Ambassador Oren began again, a second student stood up and yelled. That student was escorted out, then a third, then a fourth student. The Chancellor, Michael Drake, came to the podium and asked the audience to be respectful, so there'd be time for questions and comments at the end. But as soon as Ambassador Oren came, a fifth, a sixth, a seventh, altogether 11 students stood up and yelled so Ambassador Oren couldn't be heard, until a group of students stood up, chanted, and walked out. Ambassador Oren could finish his remarks. There was an incident almost exactly a year ago at William and Mary, following what occurred at Charlottesville in August. A lawyer for the ACLU came to speak, and students shouted, chanted, hummed, so the lawyer for the ACLU could never speak. About the same time last year, University of Oregon professor Michael Schill was going to do a State of the Campus address. A group of students stood up and yelled, chanted, sang, so he couldn't be heard. Just in July, I was supposed to be on a panel about proposed legislation to deal with the issue of police abuse. One of the other speakers was going to be San Francisco District Attorney George Gascon. As soon as he was introduced, a group of 25, 30 people in the audience yelled and chanted so that None of the panelists could be heard. They refused to be quiet, so the panel never took place. The 300 people or so who were there to hear it never got to hear it at all. My sense, though I don't know very much of the Heather McDonald incident here, is a group of students were trying to prevent Heather McDonald from being heard. I feel strongly there is no First Amendment right to keep a speaker from being heard. Now, I've repeatedly asked, but isn't in all these instances I mentioned just speech that's being used to keep others from being heard? But I don't think people have the right to use free speech to silence others. Then there would truly be a heckler's veto. Then the only speakers we'd ever hear are those where no one cares enough to try to silence them. I think it is completely appropriate for a university to discipline those who try to silence others from being able to speak. Second set of issues that we hear about a lot concern the internet. And I think that the internet is going to pose the hardest questions with regard to free speech in the years to come. I think that the internet is the most powerful medium for communication to develop since the printing press. It used to be, in order to reach a mass audience, you had to be rich enough to get a broadcast license or to own a newspaper. Now, anybody with a smartphone can reach a mass audience. Anybody who has access to a modem in a library can do that. And there's something tremendously beneficial in terms of democratizing the means of communication. But it also then means that the internet can be used to harass, to reveal very private information about people. There's even a name for it, doxing, where personal information, perhaps that a student is transgender or a student is undocumented, can be released to a mass audience. Our model with regard to free speech on campus, as I said at the beginning, is so shaped by what happened at Berkeley. We think of students on campus wanting to speak, and what can the campus do about that? The internet, social media, make the distinction between on-campus and off-campus irrelevant. When should a campus be able to punish student speech that's over social media, that's over the internet? And the law is only beginning to keep up with the technology. So I've tried to describe for you the current law with regard to freedom of speech, tried to identify at least a couple of the hard issues that are going to emerge. What I also want to do in ending is say that I believe that just as colleges and universities have a duty to protect free speech, so do they also have an obligation to create an inclusive learning environment for all students. And when hateful speech occurs on campus, I think that campus administrators have the obligation to respond. There's many things that they can do. Campus administrators themselves can speak out and condemn the offensive speech. Many years ago, when I was a professor at the University of Southern California, somebody wrote a homophobic slur on a board in a room where an openly gay teacher had just been instructing. Rather than try to figure out who wrote it and punish the student, the then dean of the law school, Scott Bice, put a letter in every student and faculty mailbox, that tells you how long ago it was, saying, this is inconsistent with the community we are and aspire to be. I learned of the swastika of Alan Dershowitz's picture at 4 o'clock on the Wednesday afternoon when he had spoken. At 8 o'clock on Thursday morning, I sent a message to all faculty, staff, and students condemning the hate speech and explaining why it's inconsistent with the community we are and aspire to be. I'm not naive. I don't believe that more speech can eliminate the hurt of hateful speech. But I do think it can go a long way to defining the community, as I say, that we are and that we aspire to be. I have seen counter demonstrations to hateful speech work very effectively. When the white supremacist Richard Spencer was going to speak at Texas A&M University, a counter rally was organized in the large Texas A&M football stadium. Thousands, maybe tens of thousands, faculty, staff, and students went to the counter demonstration. I've talked to many who were there. They discuss how it was unifying for the campus at a time when hate could have been so divisive. Last year, when there was going to be free speech week at Berkeley, I encouraged my students and others on campus to hold their own teach-ins and counter-demonstrations as a way of responding. I think that colleges and universities have a legal obligation to respond to harassment and hateful speech. I argued a case in the United States Court of Appeals for the Fourth Circuit in Richmond in May. I'm still waiting for a decision. It involves a public university there, Mary Washington University. They were debating the question of whether to allow Greek life, fraternities and sororities. A few women students spoke against this. They said that there's a correlation between the presence on campus of fraternities and violence against women. They were then targeted for harassment. There were 700 messages sent over the then social media platform Yik Yak. These messages were threatening rape, threatening murder. They were vile. And the students went to campus officials and said, "We believe you have the duty to protect us." This is under Title IX, the Civil Rights Law. Instead, a campus administrator posted on a campus website that since this was anonymous speech over social media, the campus wasn't going to and couldn't do anything. The students filed a lawsuit against the university under Title IX. It says that educational institutions that receive federal funds can't discriminate on the basis of sex. That includes preventing harassment on the basis of sex. And my argument to the Fourth Circuit was not that the campus should have necessarily punished anyone's speech, but there's so much else the campus could have and should have done. The campus administrators could have condemned the hate speech. The campus could have offered protection to the students. The campus could have offered counseling to the students. The campus could have adopted a cyberbullying policy, and so on. And my argument is that just as there's a constitutional duty to protect speech, so do campuses have a duty to protect their students. Now, I realize I may not have persuaded you about any of this. Inevitably, those who believe I've gone too far in wanting to protect freedom of speech. And I guess what I would say to you is that the only way that our speech can be secure tomorrow is to protect the speech we don't like today. We don't need freedom of speech to protect the speech we like. Society would let that go on anyway. We need freedom of speech to protect the speech we detest. And as much as I'm skeptical that there's such a thing as the marketplace of ideas that'll triumph, I'm even more dubious about letting the government have the power to decide what message to express, what messages to stop. And I think that freedom of speech, whether it's the First Amendment or commitment to academic freedom, is very much about a distrust of government power. I think that freedom of speech is based on a faith that we will all be better off in the academic institution if we allow all ideas and views to be expressed. I share that faith, at least most of the time. Thank you.
All right, we'll have time for some questions. Please raise your hand if you'd like to ask a question. Stand up when you speak, and do try to keep them brief. Priority will go to students, as always.
Hi, and thank you very much for your talk. I had a question regarding the, I suppose, directness principle and true threat to a group. You were talking about the noose on the tree versus the noose pinned on someone's door. What about a case in the middle, for example, the swastikas drawn on the Jewish Community Center? Would, in your opinion, that constitute something of a threat to the community, or is that too broad as to not?
I'm going to make your question too easy, and then I'll make it hard. There's never a First Amendment right to deface the property of another. So if somebody draws a swastika on the Jewish Community Center, that's a crime that can be punished. Now let me get to what really is the hard question. Imagine that there's a public sidewalk, and someone in chalk on the public sidewalk draws a swastika. Can that be punished? I don't think so. I think under those circumstances, it's speech that's protected by the First Amendment. I don't think that that would rise to the level of a true threat.
What do you think of school funds going towards like hotel fees and speaking fees and travel fees and food for controversial or hateful speakers?
The campus can't have a viewpoint-based policy. It must always be viewpoint neutral. So if the campus wants to give, through student activity fees, money to student groups to invite speakers, the student groups get to decide who to invite consistent with campus policy, and campus policy, at least when it comes to a public university, can't be viewpoint-based. Now, the hard question comes up of, to what extent can a campus require that the student group that organizes and invites the speaker bear those costs? The law is clear that the costs can't be such as effectively to prevent the speaker. Skokie, Illinois said, the Nazi Party can demonstrate here, but only if they post an insurance bond, and the insurance bond was so large that they weren't able to speak. And the court declared that unconstitutional. But that's true of any constitutional right. Imagine if a state says abortion is legal in the state, but has $1 million tax in order to have an abortion. That fee would clearly be unconstitutional. So the fee can't be so large as to prevent a speaker on the basis of the viewpoint of the speaker. That said, colleges and universities can require that student groups bear some of the costs of the speakers they invite. It just has to be done to the greatest extent possible in a viewpoint neutral manner.
Oh, sure. This might take a little speculation, but back when the Constitution was being written, the Federalists and the Anti-Federalists were debating the need for a Bill of Rights. Had they not come up with a Bill of Rights, how do you feel the courts would support free speech as we know it today without a First Amendment?
I think even if no Bill of Rights had been added to the Constitution in 1791, the Supreme Court would have interpreted the Constitution as protecting basic rights. And we can talk about where would they have found that within the language of the Constitution. Maybe Article 4, that no state can deprive any citizen of the state of the privilege and immunities of being a United States citizen, and try to read it into that. But I think that rights are so basic to the Constitution, ultimately they would have been found there. And I don't think it's coincidental that the First Amendment is where it is, that I think that freedom of thought is so crucial to what the Constitution was seeking to protect. And a lot of what the First Amendment is all about is freedom of thought, freedom to believe what you wish with regard to your religion and practice your religion, freedom of thought that comes from being exposed to ideas and speech, freedom of the press. So my intuition is that the court would have read these rights into the Constitution ultimately. And don't forget, every state had a state constitution. Well, every state but Rhode Island. It was still operating under a charter from King Charles II. But all the other states had state constitutions, and those state constitutions included rights as well. I think free speech was just so basic to what the framers were thinking of government. In some way, it would have been read into the Constitution. This question?
Hi, my question regards safety on college campuses. So I want to ask about speech codes. I understand that a lot of colleges have them around because they argue that it helps protect the safety of some students. However, I feel like some of them might be a bit too specific. I heard that a while back, University of West Virginia banned the words girlfriend and boyfriend because they were too gender specific. And so what's your opinion on speech codes?
Okay. I think, as I said in my remarks, every campus speech code to be considered by a court was declared unconstitutional, almost always on vagueness and overbreadth grounds. And that was true not just of the Michigan and the Wisconsin and the George Mason, but when Stanford University adopted a speech code, it was struck down as violating the Leonard Law, the California statute that, as I mentioned, says that a college, university, high school can't punish speech that a public university couldn't punish because of the First Amendment. Actually, your example, as I understand it, goes to something different than a speech code. It goes to something called microaggressions. And many campuses have put on their websites, Berkeley has, that to discourage microaggressions and boyfriend-girlfriend, I think, wasn't so much prohibited expression or prohibited speech, but saying that it's should be regarded as gendered. Microaggressions are speech, often unintentional, that hurts other people. And there's been a lot of focus on so-called microaggressions. My position as to this is, I think it's completely appropriate for colleges and universities to educate students about what speech might be regarded as hurtful or offensive by other students. But the campuses shouldn't be punishing that speech. Now, when I've said this, I've been accused of political correctness. I strongly disagree. We all learn from a young age that there's certain things that we shouldn't say in public or that are wrong to say to another person. I think it's appropriate for colleges to educate their students about what might be hurtful to others. If you look at some of the lists of things that are on microaggressions, I think they go too far. But to me, the key is students shouldn't be punished for engaging in that speech, but we can educate students about this.
Hi, could you address the issue of the conflict between Title IX and free speech? And if you know of any litigation that's arisen from that conflict?
Well, again, Title IX is the federal statute that says that educational institutions that receive federal funds cannot discriminate on the basis of sex. Courts have long held that harassment is a form of discrimination. And so campuses have the duty under Title IX to protect against harassment or discrimination on the basis of sex. The case that I argued, Feminist Majority Foundation versus Mary Washington University, is all about that issue, where the women students who I represent sued saying that the campus failed its duty under Title IX. The Supreme Court has said that part of the obligation under Title IX is that a school can't exercise deliberate indifference with regard to harassment. And the claim is that Mary Washington University did so. The campus's defense is this is all speech. There's speech over Yik Yak, the social media platform, but it was still speech, and that therefore the campus couldn't do anything about it. The district court, the federal trial court, ruled in favor of Mary Washington University. I argued the case on Tuesday, May 8th, and still waiting for decision. But it'll be interesting to see, and it's important in that regard. I made the deliberate choice when I was asked to get involved in the case to do so. I'm obviously, as you can tell, a staunch advocate of free speech and free speech on campus, but I very much believe that campuses also have the duty to protect students. Now that this was a case that has the opportunity to establish that as law. There's lots of questions here.
Hi.
Hi.
Thank you for speaking tonight. My name's Andy also. To what extent are professors held liable under the same doctrine of protecting students and free speech as administrators are? For example, is canceling class the day after Trump was elected an infringement on free speech, since that is not a policy-neutral viewpoint?
I've been talking about the importance under the First Amendment of the government or campus administrators always being content neutral. I want to draw a distinction, though, when it comes to faculty, between speech in the professional realm and speech in their personal or non-professional realm. When it comes to speech by a professor in a professional realm, there very much can be content-based evaluations. When I assign a professor, my associate dean assigns a professor to teach contracts law, and the professor says, I don't want to teach contracts law, and in protest just talks about baseball or basketball every day, I can reprimand, if necessary, discipline the professor. Admittedly, it's based on the content of what the professor has done, but this is a place we can evaluate. When we choose to promote or tenure a professor, we're obviously looking at the content of his or her work. When professors evaluate students, we're looking at the content of their exams, the content of their papers. It should never be based on the viewpoint expressed, but certainly it's based on content. On the other hand, I believe in the personal realm, professors should be able to say anything they want without fear of discipline. If a professor wants to go to a white supremacist rally or a pro-life rally or an anti-abortion rally on the weekend or Black Lives Matter rally, that should be for the professor to do, and I don't believe a campus should be able to discipline the professor for that. Now we can talk about, and I can give some recent examples of hard line drawing of what's the professional or the personal realm. So I'm going to take your question as a hypothetical having nothing to do with CMC, because I don't want to be talking about the faculty of CMC. But imagine that a professor in my law school decided to cancel classes on November 9th. My question is it because the professor was too ill to teach? And obviously, then, if the professor's too ill to teach for whatever reason, we allow people to not teach when they can't teach. On the other hand, if the professor said, I'm doing this as a protest of the election of Donald Trump, I would have to talk to them and say, I think that's inappropriate. That your job is to come teach class. The bus driver's job is to go drive the bus, however upset the bus driver is by what's going on in the world. You still have to do your job. Have I addressed your question? I know there's some hands over there, too.
I have a question back here, sorry.
Sure. I don't see you. Oh, now I see you.
Yeah.
Hi, my name's Zach. I'm a senior at CMC. You said that the public universities can't prohibit speech, but is there any law adjudicating whether or not they can take a public stance on a certain type of speech?
Let me talk first about campus administrators and then talk about the campus itself. I believe that campus administrators very much can, and I think sometimes should be taking positions on things. My example is when there's something hateful that occurs, I'm going to take a position as the dean of the law school that condemns it. I write op-eds all the time, literally every week. I take positions on issues. I'm speaking as an individual. I'm not speaking for the University of California Berkeley School of Law or the University of California, but admittedly, there's an identification paragraph that says what I do. So I have no problem with individuals taking positions and sometimes think they should. In terms of institutions, it's a much harder question. When it comes to the University of California, only the regents of the University of California have the authority to take a position officially for the University of California. The chancellor will, I think, may also exercise some authority, but I can't speak for the University of California Berkeley Law School. And I can speak for myself, and I often do. I imagine within private universities, there's something in terms of what can the trustees speak for, when can the president of the university speak for the university. And I think there are times when it's absolutely appropriate and necessary for the university to take positions. I want my university to take a strong position in favor of free speech, but also a position in terms of creating an inclusive learning environment for all students.
So my question is, you mentioned about how Europe has more restrictions on the freedom of speech. Obviously, recognizing that Europe is a diverse continent, do you think Europe is trending towards the American model towards free speech, or continuing to place more restrictions?
It's a great question. Hate speech laws have long existed on the continent. And I spent a lot of time looking to see how these laws have been used. Impressionistically, but this is very impressionistic, I think that they're used less now than they were for a while. So it may be that there's more of a movement towards tolerating hateful speech, but I don't want to overstate that, and it's not based on anything that comes close to a study. It's just looking at lots of cases. I know there were some hands over here. No?
I have a question.
Okay.
Do you think there are any serious legal threats against the First Amendment? I'm thinking of a constitutional convention, but anything?
I think free speech is deeply entrenched in our society. And if there's any issue where liberals and conservatives may come together right now, it's in the commitment to free speech. Certainly I find among conservatives substantial agreement with much of what I've said to you tonight. I think most liberals would agree with it. So I don't see free speech as being vulnerable at this moment in history. That could change. It's often changed, especially in times of crisis. I think what's going to come up with regard to free speech, and it's beyond the scope of my talk, is that increasingly conservatives are going to use free speech to challenge social legislation. It's what Justice Kagan referred to in her dissent in Janus versus American Federation on June 27th is weaponizing the First Amendment. So there was a California law that required that facilities that provide reproductive health care post a notice that says the state of California will make free and low-cost contraception abortions available to women who economically qualify, and unlicensed facilities had to disclose that. That was struck down by the Supreme Court in a way that I think it's going to put a lot of disclosure laws at risk. The Janus case I mentioned involved a law in California, or that came from Illinois, but California has a similar law that required that non-union members pay the share of the union dues that go to support the collective bargaining activities of the union. That was struck down for violating the First Amendment. So I think what we may see is how the First Amendment, in Justice Kagan's words, gets weaponized and used to challenge other social and economic welfare legislation. And maybe another way I can answer the question, on September 17th, just a few weeks ago, the Attorney General, Jeff Sessions, held a program in Washington where we talked about the crisis of free speech on campus. The same day, Betsy DeVos spoke at the National Constitution Center in Philadelphia and spoke about the crisis of free speech on campus. I don't see a crisis of free speech on campus. Come to the Berkeley campus literally any day and walk across Sproul Plaza, and there's people with picket signs, students gathering signatures on petitions, handing out buttons on the like. I get to go to a number of campuses over the course of the year. Free speech is going on all of the time. There are some hard instances. There are some places where sometimes colleges, universities go too far in restricting speech, but I don't see a free speech crisis in our country, even though there may be difficult issues that are going to come up and have to be resolved. Silence.
If there are no more questions, please join me in thanking Dean Chemerinsky.
Thank you.